private hospital is threatening to discipline nurses because they won't treat COVID-19 patients because they don't have adequate PPE. That's a headline I woke up to this morning. Here it is here in this HSJ article. It came to me first thing this morning. There you can see the headline there, private hospital threatens nurses refusing to treat COVID-19 patients. And it says here that nurses at private hospital face disciplinary action for refusing to help with COVID-19 patients. And if we go further down here, you can see there's a statement here by the Royal College of Nursing. It says, in its guidance, the RCN said, if you have exhausted all other measures to reduce the risk and you have not been given appropriate PPE in line with the UK infection prevention and control guidance, you are entitled to refuse to work. And that's great. But also, the Health and Safety at Work Act and the regulations that support it, the statutory regulations, make it quite clear too. Let me show you those. Now, this is health and safety legislation, and I'm not going to go into it in depth because I'm sure most of you watching this know about health and safety legislation, at least Section 2 of the Act, which is the duty of care the employer has to its employees, and that is an Act of Parliament. So that's a primary piece of legislation. It is law, and we must comply with it. All organisations must comply with it, and that tells us what we must and must not do. Underneath that, you have management regulations, and these are statutory instruments that tell us more specifically how we should do what is required. So, in terms of the duty of care owed to staff, these management regulations tell us specifically what we need to do to comply with that, and therefore comply with the Act of Parliament. And this is Regulation 8(2) of the Management of Health and Safety at Work Regulations 1999, procedures for serious or imminent danger and for dangerous areas. And it says, so far as is practicable, require any persons at work who are exposed to serious and imminent danger to be informed of the nature of the hazard and of the protective steps taken or to be taken to protect them from it. Part B says, enable the persons concerned, if necessary, by taking appropriate steps in the absence of guidance or instruction and in the light of their knowledge and the technical means at their disposal, to stop work and immediately proceed to a place of safety in the event of their being exposed to serious and imminent and unavoidable danger. And Part C says, save in exceptional cases for reasons duly substantiated, which cases and reasons shall be specified in those procedures, require the persons concerned to be prevented from resuming work in any situation where there is still a serious and imminent danger. Now, that's law, okay? So staff can stop work and go to a place of safety and refuse to return whilst that danger is still there. There's more. There's the Employment Rights Act 1996. This is Section 44, Health and Safety Cases. And Section 44 gives employees the right not to be subjected to any detriment by any act or any deliberate failure to act by his employer done on the ground that 1D, in circumstances of danger which the employee reasonably believed to be serious and imminent and which he could not reasonably have been expected to avert, he left or proposed to leave, or, while the danger persisted, refused to return to his place of work or any dangerous part of his place of work, or, in circumstances of danger which the employee reasonably believed to be serious and imminent, he took or proposed to take appropriate steps to protect himself or other persons from the danger. And Section 100 goes on to say, an employee who is dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal is that in circumstances of danger which the employee reasonably believed to be serious and imminent and which he could not reasonably have been expected to avert, he left or proposed to leave, or, while the danger persisted, refused to return to his place of work or any dangerous part of his place of work, or, in circumstances of danger which the employee reasonably believed to be serious and imminent, he took or proposed to take appropriate steps to protect himself or other persons from the danger. So that's what the law says. And once again, as far as I'm aware, the law has not been suspended, amended, or redacted in any way, shape, or form. Okay? And no one is immune from this. Let me show you a few more cases. Right, this is in the Daily Record. Okay? And this is on the 16th of Feb this year. Ministry of Defence faces £100 million compensation bill for post-combat deafness. And it's already paid out almost £70 million to over 10,000 troops found to have hearing loss or severe tinnitus caused by the noise of battle. Now, if you look down here, it goes on to say that all troops are given earplugs or headphones to use during live firing training, but many ditch the hearing protection during firefights in Afghanistan and Iraq as they cause communication problems. And it goes on to say the average payout was about 14,500, but some High Court awards have hit six figures, with lawyers arguing troops should be compensated for loss of future earnings. And it's an interesting one, but there's more. There was a situation in Iraq where the army were issued with Land Rovers with inappropriate armour on them, and they blew up and people died. Now, the Supreme Court ruled in June 2013 that families can sue. So the Ministry of Defence lost its Crown immunity in this case. So soldiers going into battle, if they are not prepared or are not given the appropriate personal protective equipment or the correct armour, and they die as a result of that, and the inquiry into this case did find that they were given inadequate Land Rovers, then the families can sue. And the MOD paid £750,000 on legal fees, denying responsibility for soldiers' deaths in recent cases. So you can see the cost of this, all right? And the MOD took taxpayers' money, £750,000, to try and fight the cases which they lost, okay? Bottom line with this is, you can't put service personnel in war zones with inadequate PPE, equipment and training, and then if they get seriously injured or killed, try to say that they can't sue you. The law is the law. In the same way, you can't put a nurse or a healthcare worker or a care assistant in a war zone. And I'm calling it a war zone because this virus is killing people. You can't put them in that environment without the correct PPE, the correct training, whatever they need, and then discipline them if they don't feel safe and they want to go home. And I think any employer that goes down the route of disciplinary action against staff who are refusing to treat COVID-19 patients because they have not been given the appropriate or necessary personal protective equipment is on a serious slippery slope, as these cases prove and as the law clearly states. And as I've said on previous videos, lawyers are gearing up for a tidal wave of claims coming in after this pandemic is finished. It's absolutely inappropriate for employers to not provide PPE in the first place. And yes, I know there's a shortage, but to discipline staff who are just scared and trying to keep themselves safe and not go home and infect their families, it's absolutely shocking. Now, guys, feel free to share this. People need to know about this stuff. The law has not been suspended, redacted, amended, or changed in any way, shape, or form. The law is the law, and I've just given it to you there. Okay, I've shown you the cases. The MOD does not have Crown immunity. Okay, nursing staff, healthcare workers, and care staff need to have the kit, and I think it's absolutely disgusting that a private hospital would threaten staff with disciplinary action because they're scared and they don't want to treat COVID-19 patients because they don't have PPE. I know it's a sensitive issue. I know these are difficult times. I feel for the families of the patients who are in these places, but the staff have families too, okay? And this virus, this pandemic, is taking good healthcare workers away from us. They're dying every day trying to save the lives of other people. I don't know what else to say on it actually, so just share this far and wide if you want. There's a link below. You can subscribe to our newsletter feed if you want to hear more from me. It'll come straight to your email box every time I put something out, and I'm putting something out literally every day on this now. But also, guys, I've spoken about healthcare workers and care staff here. This also applies to any of you who are expected to use force in the workplace too. The rules are exactly the same, okay? So if you are expected to go and physically restrain someone, you've got to have the right PPE. They shouldn't be expecting you to do it. That's why I put out the risk assessment. I'll leave a link to that below as well, and you can access that and share that around as much as you like. But guys, please share this video. Let's get this word out there. Staff should, doing, you care staff, you NHS staff, you're absolute heroes. Serious to God, you're absolute heroes. And I'm shocked and horrified that they want to discipline you because you're scared. I nearly swore then, I'm sorry, it just shocked me. But first thing this morning I got this, that's why I'm doing this video. Thanks ever so much, guys. Have a great day, stay safe, and you guys look after yourselves. Speak to you soon.